Okay, so the last video we just covered preliminary hearings. So assuming that the charges were bound over following a formal hearing, or whether you signed a waiver of the preliminary hearing, your next court date is going to be formal arraignment. And what is formal arraignment? Formal arraignment is basically you had a preliminary arraignment that was in front of the magistrate judge. Then you get arraigned again in front of the next judge because your case has now been held into the Court of Common Pleas. You're not in front of the magistrate anymore. Your time with the magistrate is over. You're moving on. You're percolating through the system. And at this stage is your first time going in front of the Common Pleas judge, right? The legal judge, the judge who potentially might be the judge presiding over your case at trial. And what technically happens there if you decide to go to it in person is you were told what you're charged with, and they ask you, how do you plead? And you see this in the news all the time, like so-and-so pled not guilty. Can you believe that? The reality is everybody should plead not guilty at formal arraignment. There's really no reason to plead guilty. But basically, they ask for your plea, your formal plea on the record. How do you plead to these charges? Guilty or not guilty? I think at one point in time, years ago, you could actually plead guilty. You could, I couldn't think of any strategic reason for doing so, though. I mean, at this point, you don't have discovery. They haven't even made an offer in the case yet. So you'd just be pleading open to the charges. But anywho, that's neither here nor there. We're not going to get into all that right now. Basically, that's it. You get in your car, you drive down to the courthouse. They say, how do you plead? And you say not guilty. You can't even say guilty if you wanted to. If you said guilty, they would say, oh, what? No, you can't even plead guilty right now. So just say not guilty. If you want to plead guilty, you could do that in the future. So it is a very meaningless court date. Every 99% of the time, your attorney, if you're represented by an attorney from the public defender's office, they're going to give you a piece of paper that says waiving the formal arraignment. And you're really not even waiving the formal arraignment. It's still going to happen. All you're waiving is your appearance there. Where it's just a piece of paper and you can say not guilty. I plead not guilty right now, and then I don't physically have to go to court a month from now to just say not guilty on the record. A lot of people do get, you get people who are very skeptical about signing anything because they think they're giving away some rights to the government, which sometimes you should be skeptical of anything you put your name on. But for formal arraignment, you are not waiving anything. You're not waiving Rule 600. You're not waiving any speedy trial rights. You're really just waiving your appearance. It just makes everything. If there's one thing to waive, it's this hearing. You're just wasting your gas. So there are some important things about the formal arraignment, but it's not really for the defendant. This is more for attorneys. So if you're just getting involved in criminal practice, you just got out of law school. The important thing is the timelines that it sets. So the date of formal arraignment sets the timeline for when you're entitled to discovery in the case. So after the formal arraignment has been handled, that's when you can make a request upon the DA, assuming that a trial DA has been assigned to the case. And you would say, at this time, we're requesting discovery in this case. And they have to turn that over within 30 days. So it starts that. And so what is discovery? Discovery is basically, for the most part, it's all the documentary evidence that the Commonwealth would probably try to use against you or your client at trial. So it's police reports, it's dash cam footage, it's the results of any lab testing, if there was DNA testing or testing, lab testing drugs, any written statements, your client's prior record. So it's a bunch of stuff. It depends on the case. It depends on what the discovery is going to show. And the other thing is that it sets the time frame for filing a omnibus pretrial motion. So if you believe that there's some issue in the case, as far as, there was an illegal stop or there was an illegal search, we talked about how that's not relevant at a preliminary hearing. You don't get to make those arguments at the preliminary hearing. This is when you make them. You prepare a written motion called an omnibus pretrial motion that alleges specifically what you're saying they violated, and then you should get a hearing date. Technically, I don't think you're entitled to a hearing, but generally they're going to give you a hearing date to determine whether or not the Commonwealth did violate some provision of the Constitution in obtaining evidence against your client, whether it should be excluded. And so that has to be filed within 30 days. And if not, you have to file an extension for time. Now, some counties are a lot more lenient than others. So again, always talk to your attorney about the timeframes, because if you do miss it, then technically you potentially are waiving those issues. You're waiving the right to challenge the admissibility of this evidence for particular reasons. And so, so it's important that, you make that motion as soon as possible. Now, there are going to be times where you're going to need more time because the Commonwealth doesn't get you discovery timely, or you get additional discovery because you might not get everything right away at the beginning, and they send you more stuff like a month later, and you didn't even know there was a suppression issue until you got the new stuff. So that would also be a basis. You would probably file a nunc-pro-tunc motion, or if you already filed an omnibus pretrial motion, you would file an amended motion based upon the receipt of new discovery, new evidence in the case. A lot of judges are, more lenient with that, with the timeframes for filing those motions, but you really want to know what your judge's position is on that. You don't want to risk that. That's pretty important. So that's formal arraignment. You go in, you say not guilty, and then the timelines start to run. The next video is going to be on the pretrial conference date or status date.